night on the CINA 102.3 app at CINAFM.com, on TuneIn, on Smart Speaker, and at 102.3 FM. CINA Radio, every device, everywhere. The following program does not necessarily reflect the opinions of the management, staff, or advertisers of CINA Radio.
Joumana Kayrouz. You've seen her images on giant billboards across the metro. Joumana Kayrouz. You've seen her images on buses across the city. Now get to know Joumana Kayrouz.
The war broke out in my home country, Lebanon. I was 11 years old, and I saw a lot of bloodshed and inequality and poverty. You can't grow up in an environment like that and not be affected by it and not want to make a difference. I graduated from Yale University with a master's in ethics. I speak 4 languages. It has always been innate in me fighting for the underdog and trying to do whatever it is I can to make a difference in the world.
Let Joumana Kayrouz protect your rights. Call the law offices of Joumana Kayrouz at 1-866-YOUR-RIGHTS, extension 100, or visit yourrights.com.
برنامج يور رايتس مع المحامية جومانا كيروز المختصة في قضايا حوادث السيارات، مع نخبة من المحامين في اختصاصات عدة منها الطلاق والهجرة والإفلاس، يأتيكم الآن على الهواء مباشرة. حلقات تتضمن مواضيع ومعلومات شيقة في برنامج يور رايتس تتابعوها على راديو سينا 102.3 FM 4 أيام في الأسبوع، وبالتأكيد مع المحامية جومانا كيروز. مكاتب المحامية جومانا كيروز تستقبل قضاياكم المتعلقة بالبيرسونال انجريز، كار اكسيدنتس، immigration، bankruptcy، criminal law، family law، social security، ودائما الاستشارات مجانية. 248-557-3645. حلقات برنامج يور رايتس موجودة على yourrights.com yourrights.com/radio، وأيضا موجودة على اليوتيوب. كل ما عليكم هو البحث عن قناة جومانا كيروز. تحياتنا لكم مستمعينا، ونرحب أيضا بجومانا. واليوم موضوع وحلقة جديدة من برنامجنا. أهلا وسهلا فيك جومانا في راديو سينا.
صباح الخير رامي، صباح الخير لكل المستمعين، صباح الخير لضيفي المحامي هاورد رادنر اللي بيطلع معي على الهوا للمرة الثانية، واللي بإذن الله كل شهر بيطلع معنا على الهوا مرة، من المحاميين النوادر المبدعين في قانون الانزلاق، premises liability، slip and fall، trip and fall. Truly an outstanding genius. Correct, Attorney Howard Radner?
بالفعل.
Based on your settlements and verdicts. How about that?
فاليوم الموضوع عن الانزلاق إن شاء الله. بس قبل ما نبلش بالموضوع هذا وأترككم يعني أترك الحديث لكم جومانا، حابين نباركك ألف مبروك. سمعنا عن سيتلمنت امبارح كان في مكتبك، قضية تسوية بحادث سيارة، وكان المبلغ يعني كبير، $750,000. يعني نجاح يضاف إلى سلسلة النجاحات لمكتبكم. ألف مبروك.
Thank you very much رامي. نعم، نحن فخورين انه امبارح عملنا تسوية $750,000 لعائلة. ما بدي اعطي كتير تفاصيل لانه لربما يقدر حدا من المستمعين يعرف عن مين عم بحكي. لعائلة رح نقول عربية كلدانية، إصابة هائلة ضد ترك. قدرنا عملنا تسوية $750,000. للحقيقة كان فينا نعمل تسوية أكتر من هيك بكتير، بس الموكل تبعنا كان مبين على البوليس كام اللي كانت مفتوحة إنه كان مسرع. نحن طبعا our argument is that السرعة مش هي اللي سببت الإصابات، وإنما المحاميين تبع الترك، واللي هي شركة عالمية على فكرة، they hammered down that point. يعني استعملوا هيدي النقطة كل الوقت، إنه هو مسرع، إنه لو هو منه مسرع كان بيقدر يتحاشى هيدا الحادث. معناتها هو كمان contributory negligent، يعني هو كمان ساهم بالإهمال. so عارفين من البداية، من بعد ما حصلنا على البلاك بوكس تبع السيارة والبلاك بوكس تبع الترك، عرفنا إنه it's going to be an issue. السرعة is going to be an issue. فالقيمة هي بتتخطى الملايين، بس بما إنه السرعة was a factor، يعني إذا بدنا نروح على المحكمة نعمل تراير، رح نحط مصيرنا بين إيدين 7 أشخاص. يمكن يعجبهم الموكل يمكن ما يعجبهم، يمكن يعتبروه انه هو غريب، ليش عم يجي يطلب منا مصاري، يمكن يقرروا انه السرعة هي كانت العامل الاكبر، يمكن ما يعطوه ولا فرنك بتاتا. وقت اللي بيروح الانسان على ترايل، وهلا بيأكد لنا هالشيء المحامي هاورد رادنر، عم نحط ايدينا بين ايدين مش القاضي، لأنه القاضي فقط بيطبق القانون، بس بين إيدين الجوري اللي هن 7 أشخاص، 6 وفرد alternate على جنب، هن اللي بيقرروا، وما فيك تستأنف قرارهم. ما فيك تستأنف إلا خطأ من قبل قاضي. يعني إذا القاضي بقلب الجوري ترايل did not apply the law correctly، فيك تستأنف، you can appeal. بس إذا ما عجبك الريزالت تبع الجوري، ما فيك تستأنف. المخاطرة كانت هون إنه إذا بدنا نفوت على المحكمة بدنا نواجه 7 ما بنعرف كيف رح يفكروا، كيف رح يحللوا، شو رح ياخدوا قرار. أوقات كتير بيضطر الإنسان يعمل ترايل وقت اللي بيكونوا عارضين مبلغ كتير قليل، وبيكونوا عارضين مبلغ كتير قليل ما عندك شي تخسر. بيعرضوا عليك 50,000 50,000 دولار 100,000 دولار بكيس مثل هيدا، ما عندك شي تخسر، لأنه فقط اللي على الطاولة هو هالقد. بس وقت اللي بيبلش العرض يكبر أكتر وأكتر، هون يعني بدك تتصرف بتحذر. بدك تفكر إنه بيقول في مثل بالعربي بيقول عصفور بالإيد ولا 20 على الشجرة. العصفور اللي كان بإيدينا هو طلع من 150 ل750 ألف دولار، ولا ملايين على الشجرة، لأنه الملايين على الشجرة غير مضمونين. كمان مرة هيدا الكيس كان عنده a big problem اللي هي السرعة. طبعا نحن our position كانت إنه السرعة مش هي العامل اللي سبب الحادث، but ما بتعرف الجورز كيف بيفكروا. You don't know at all. شكرا،
ألف مبروك مرة ثانية.
Thank you very much. للأسف أنا بتمنى لو ما بيصير حادث سيارة وحيد بهالدنيا، وبتمنى لو بغير اختصاصي 100%، لأنه ما بعود في حاجة لهذا الاختصاص. بس للأسف ما حدا بيقوم وبيقول أنا نيت اليوم أتعرض لحادث سيارة. Yes. شكرا رامي. كمان مرة نحن منذكر انه ضيفنا اليوم المحامي هاورد رادنر اللي هو اختصاصي. هاورد, would you be so kind to remind me how many years of experience?
44 years.
44. I was not born by then. Well, that's my story and I'm sticking to it. How about that? Okay, you can laugh. It's almost like you're not convinced. Fine, I admit I was 10 years old at the time. 44 years is so much experience. You were with us a month ago. You impressed a lot of listeners. I want today to open the phone to anyone who wants to call about a slip and fall, about a trip and fall. It could have been outside your apartment. It could have been in a shopping mall. It could have been visiting somebody. It could have been somebody getting injured at your home. It could be inside the hospital, inside a public facility, on a roadside, on a sidewalk. It could be because your landlord is not cleaning the snow and the ice, and you have no other way of, getting to your car. Any of those are discussions we're going to have today. It's called premises liability, slip and fall, trip and fall. And we said last time, Howard, about the extent of the injuries people do not appreciate. And I want to begin by saying that the number one goal for everyone, including yourself, because I know who you are and what values you stand for, we want to help people avoid getting injured. So we want to also give tips about snow, about ice, about walking in the snow and the ice, about driving in the snow and the ice, correct? But I am reminded of my first job when I worked for the very famous, one of the top lawyers in the United States, the late Harry Philo. He is called the father of product liability. And he used to always say, the purpose of tort is injury prevention. But when that fails, then money compensation. So as good lawyers, we want to lobby and we want to litigate so as to improve the system so that in due time there are less injuries. Whether it is a product that you want to improve, whether it is a car that's defective that you want to improve, whether it is workplace conditions that you want to improve, whether it is medical errors that you want to improve, whether it is, conducting business in a store for the safety of the visitors and you want to improve. Truly, the goal behind all this is to prevent injury, to produce a better product, to produce a safer work environment, to produce safer walking, avenues. But unfortunately, sometimes that fails. And when that fails, then you want to get money for your client. So our goal here too, and I want to hear your thoughts on that, is we want things to be safer. But we know that sometimes that is not the case. And a client is injured as a result of someone's negligence. In that case, we want to get them money prevention. We want to money compensation. We want to get them money, because all the money in the world is not going to take away your injury, is not going to turn back the wheels of time. You agree?
Absolutely.
Okay, I think you need to get a little bit closer to the microphone. Okay, very good. So, but however, most of what we do in our day-to-day is money compensation. But in the filing of every legitimate lawsuit, we are improving the system, correct? Sometimes the legal system is not fair and is not accurate and is not just. And sometimes people do not find justice in the legal system. But that does not mean that the filing of that lawsuit that was legitimate, that does not mean that just by filing the lawsuit, you did not improve the system. I will give you a quick example. I had somebody call me regarding a medical malpractice case. Long story short, this person, will keep it very vague because I don't want people to know who we're talking about. This person lost his vision as a result of what we call the negligence of the eye doctor who replaced the lens incorrectly. And long story short, the doctor was sued in Oakland County, and very, very sadly, the jury returned a no cause. The jury decided that the doctor is not negligent. This thing has been going on for 2.5 years, and I have got to believe that that doctor who was wrong, who kicked the patient out of the clinic, who insisted on cash in order to look at his eye a second time again, only the jury never got to hear any of this because of a motion in limine that kept all this out. So the jury couldn't, but the doctor knows. And I have got to believe that as a result of that litigation, the doctor is reconsidering the way he has done things. And the idea is that he promises himself, if for no reason other than to avoid being, sued again, that he will improve his systems. He will offer better customer service. So even when you lose in a lawsuit, you win, because if you file the lawsuit legitimately, you are inviting people on the other side to think about what they've done and how they can improve it so that they don't get sued the second time or again and again. Let's talk about shopping malls. Or, for example, people who are shopping at Myers, the Kroger's, and there is something on the floor. Does that mean that we can sue Myers? Does that mean that we can sue Kroger's? Give us examples of times when you cannot sue because the law simply says they haven't done anything wrong, although there is something on the floor. Give us examples of times when it's the opposite.
Sure. Well, actually, somebody called yesterday who fell on a floor at one of the grocery stores due to a grape. One grape.
What was the color of the grape?
I'm sorry, it was not a grape. Hold on, it was not a grape. It was a blueberry.
A blueberry, okay. And so the color is blue.
The color is blue. The lady said that she tripped over the blueberry and went down and injured her knee.
Okay.
And the store did not want to compensate her or even pay for her medical bills.
Right. And speaking very quickly about that, a lot of stores may have what's called Medpay. Their insurance company offers treatment up to $1,000, $2,000, $5,000 for any injury, regardless of whether they're at fault or not, that happened on their premises, and many don't, correct?
Yes.
Okay.
But even if they have that coverage, you can't force them to pay it.
Okay.
So it's an interesting part of our law here in Michigan that even if a company has Medpay coverage, the injured party is not automatically entitled to that.
Who decides?
The insurance company. And you cannot sue the insurance company to force them to pay your medical bills.
Okay.
So this person I had to turn down because I asked her how long was the blueberry on the floor, and she said, I have no idea.
Well, she would have no idea because she is not an employee of the store. So maybe we asked the question of the wrong person. But my question to you is, it's a blueberry. So by definition, it is blue. And so she could or should have seen it.
Open and obvious.
So it is open and obvious. So let's talk about what open and obvious means.
Open and obvious means that if something is visible on casual inspection, then you cannot sue the property owner for not removing it.
Okay. So even assuming that the blueberry was there for a long time, and even assuming that the store should have made its rounds, and had they done that, they would have discovered the blueberry and taken care of it. Even assuming all of that, the law, the sad law here in Michigan says, well, what were you doing not looking? Had you looked casually, you would have seen that blue thing on the floor there to be seen, and you could have avoided the injury. And so it's open and it's obvious, meaning it's obvious to the eye that you can see it. It's open for people to see. So based on that, you will not be able to sue the grocery store.
Correct.
Okay.
There were some court decisions that said, by the way, that in a grocery store, a customer has a right to look up at merchandise from time to time, and that they're not required to look down at all times. So in a certain case, it could be possible to maintain a lawsuit against a grocery store, even if it may be open and obvious. But if the person was looking at the merchandise that was on display and then fell over something, it could be, under some decisions, a viable case.
Okay, so what I learned from that is don't play lawyer, consult with a lawyer who will look at the specific facts of your case, because we are speaking generally here. But what we're saying is for legal education, is to alert the listeners to what the law is and what the theories are in premises liability, in slip and fall and trip and fall. But that as it pertains to their particular case, they need to seek a consultation with an attorney who specializes in these matters.
Sure.
Okay. I want to remind the listeners, we are talking to attorney Howard Radner, who has 44 years of experience doing, among other things, representing people who are injured as a result of a slip and fall or a trip and fall, whether it is in a building, whether it is as a tenant, whether it is visiting a shopping mall, a hospital, walking on the sidewalk against the city, etc. The numbers here to call are 313-769-6666 and 519-256-1023. And we take a call, Rami. Hello? 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 Okay, we will ask the caller to call again. Again, the number is 313-769-6666 or 519-256-1023. One of the big settlements, or was it a verdict, in the multi-millions was by you against a landlord in Flint, correct?
That was against the city of Flint.
That was against the city.
I beg your pardon. You're thinking of that, yeah. Yeah, it was against the landlord, the $2 million verdict.
Okay, tell us again about that $2 million verdict against a landlord.
That's right. That was a lady that was living in the apartment building, and the railing gave way. it wobbled, and she fell down the stairs, broke her ankle, had several surgeries on the ankle.
Okay.
Very serious fracture.
Okay. And what are we saying that the landlord should have done that she or he did not do?
Well, the landlord is required to periodically inspect his property to make sure that it's fit. And in this case, it was a common area, so he was required to make sure that the railing was fit for its intended purposes. And he didn't do that because it was wobbly and it was not fixed until after the accident.
Should the landlord have received notice from a tenant that the railing was wobbly, or under its duty to periodically examine the premises, it will have discovered it and fixed it, therefore avoiding the injury?
Right. The landlord has a duty to provide a reasonably safe premises to the tenants and to the visitors, and therefore has a duty to make periodic inspections of his property.
Okay, so even without anyone calling the landlord to report a wobbling railing, the landlord has a duty to every now and then periodically inspect the premises. And when we talk about the premises right here, we're talking about the common areas, meaning the areas that are used by more than one tenant, such as the railway, the elevator, the hallway,
sidewalks outside, parking lots.
Okay. And how do courts read periodic inspection? Is it days? Is it weeks?
There's no fixed number.
It depends.
It's reasonable.
It's what would a reasonable landlord who maybe more traffic requires more periodic inspections because more people are using the common areas.
Certainly.
So if you have a multi-unit building, then things can go wrong faster. And so perhaps periodic inspection can be read to be, in a short period of time.
Right.
Okay. Mm-hmm. And the $2 million that you got against the landlord in Flint, was that paid by their insurance company?
Yes, it was.
Okay. Because unfortunately, if the landlord does not have insurance, then in all likelihood, depending on how much more assets she or he has, will file for bankruptcy.
That's exactly right. In fact, one of the cases you referred to me, that's exactly what happened. The landlord was uninsured. We took a judgment against him for, I think it was $250,000 for a broken wrist, and then he filed for bankruptcy.
Because the landlord that you're talking to us about, against whom you got a verdict, was it a settlement or a verdict?
The $250?
No, the $2 million.
That was a verdict. That was a jury verdict.
So you went to court in front of 7 jurors and you convinced them
Yes.
that your client is injured, and that the injury of the client was because of the negligence of the landlord, and you were able to collect on the judgment because the landlord had insurance.
Right.
A number of our listeners rent homes from single homes, small homes, $50,000, $100,000, $150,000 homes from landlords who sometimes are not insured. So what happens then? This is one of those cases where you got a verdict. The $250,000.
That was a default judgment, actually.
That was a default judgment.
Yep.
So the landlord never answered your complaint.
Correct.
Okay. What can we tell, if anything, listeners about trying to avoid renting homes from landlords who are not insured?
Make sure before you sign the lease that the landlord is insured.
But that does not mean that the landlord will not let the insurance lapse. Let's say you have a 1-year lease. So I see today that you have an insurance to protect me, and I know my lease expires in 1 year, and I will make sure again 1 year from now that you have insurance. That does not mean that between today and next year you haven't let your insurance lapse.
Contact the landlord and ask him for the name of the insurance agent and verify that there's still coverage before you renew.
Correct. And you have some power to do that and some clout to do that because the landlord is vested in you wanting to renew. So we'll provide you with that information.
He should, if he's insured.
Yes.
If
When
he
a landlord
refuses to give it to you, then he's probably not insured.
Okay, that's a good point. Would you encourage our listeners to do that?
Yes. Before you renew the lease, make sure the landlord
Before
is
you
insured.
sign and before you renew.
Yes.
Before you sign and before you renew. And will that request look odd to some landlords?
It may.
Okay.
Do it anyway.
Do it anyways.
To protect yourself.
And like you said, if a landlord does have insurance, the landlord should not hesitate to provide that. But a hesitation or resistance with that request may mean that the landlord is not insured.
That's right.
Okay.
Don't be intimidated.
Okay.
You're protecting yourself and your family.
Yourself and your family, indeed. What about people who own homes and they have homeowners insurance and one of the homeowners is injured? Is the homeowners there for the protection of the homeowners? The answer is no. Okay. No. And tell us why, and tell us therefore why do we buy homeowners insurance?
The homeowner is insuring himself against a lawsuit against him.
From someone visiting the home.
That's right.
And getting injured.
That's right.
As a result of the negligence of the homeowner.
That's right.
Does the homeowner's insurance also cover the contents of a home?
Yes.
So the contents as well as injury.
And fire.
Mm-hmm. Does it cover the front door? Does it cover the driveway? Does it cover the sidewalk right in front of the door? If an injury, say by a postman or by a delivery person, these are called business invitees, correct?
Yes.
Yes. So what happens if there is an injury by whether it's a social guest or whether it is a business invitee, such as the postman or the UPS? What happens? For example, nowadays, we have ice and the conditions are pretty treacherous at times.
So if the homeowner gets sued because somebody falls on his property, the homeowner should immediately contact his insurance company and turn the papers over to the insurance company. They'll hire a law firm to defend the homeowner. For
free. That's part of what you buy.
That's right. That's what you're paying the premium for.
Okay. And will if negligence is established, will a postman or will the Amazon delivery person or will the friend who is coming to visit be covered by the homeowner's insurance?
Up to the limit, up to the policy limit.
Up to the limit.
Yes.
But that homeowner's insurance will cover scenarios like these.
Yes.
What advice, I know we're kind of jumping, but one discussion is backing the next. What advice can you tell people, homeowners, about de-icing the areas getting to their home? Sure. What are you doing with your own home, Howard?
Well, I have a contractor that comes and removes the snow.
Okay.
Following any snowfall. Mm-hmm. Then I salt the driveway and the sidewalks myself.
Okay. How often do you do that?
I do it whenever it snows and whenever there's ice on the property.
So you make yourself alert to what's going on as far as the weather, and you go out periodically and you de-ice the front area and all the areas of access to the home.
That's right.
And do you do that? Of course you do that for the safety of others first and foremost. But will that also protect you, God forbid, in the event of an injury?
Sure. Because if I acted reasonably and protected visitors from injury, and they're injured, I will have a very good defense that I acted reasonably, that I did the best I could to make the property safe.
Okay, so it's not that you have to; it's putting caring about people aside. Legally speaking, it's not that you have to, but if you do, then you have shown that you have taken all the reasonable measures, all the measures within reason that you can do to keep your premises safe.
Sure, and it doesn't take that much time, really, to sprinkle salt on your sidewalk or your driveway.
Well, not if you have a big area in the front and you have the driveway and you have the entrance right directly to your front door, and then you have back on the garage. And I mean, that area can be quite large.
It could be, yeah. Well, there are contractors, if you have a large driveway,
but the
who will spread salt, you have to pay a little more for it.
Mm-hmm.
But the contractors are willing to drop salt as well if you'll pay for it.
However, those contractors typically come only when they are removing snow.
Yes.
They're not going to come because the temperature has gone down and there is no snow, but the conditions are now icy.
Mm-hmm.
They won't come. So you do have a duty.
Yes, you do. If
and
they
I think,
yes.
And I think a good rule of thumb is if you're concerned about if your area in the front is large enough, you can't walk out there because it's very icy. Then you can get in your car and take the salt with you and drive with your door open and try to throw the salt this way.
You could.
This way you can cover that large area. You are in a vehicle that's running and you can. How effective is salt? How long does it last? Its effect.
That's a good question. It depends on the temperature outside. It depends how thick the ice is. If it's thicker and if it's colder, it'll take much longer to melt.
Okay. And once it melts, it's not effective anymore.
Well, then the water dissipates. It's gone.
Okay.
It just doesn't melt and turn into water, but it evaporates in the air.
So once it melts, it's not there anymore.
Right.
So in other words, we can't say, well, we put salt yesterday. If it's melted, it's not there anymore. So it's not effective anymore. So you have to put salt again.
You might have to.
Okay. So what tells us if what we did yesterday or the day before or this morning as far as throwing salt is still effective is by looking at it. If it's still looking in granules, that means it has not melted. So it is still there for your protection and the protection of others. But if it has melted and evaporated, then the salt you put is gone. You have to reapply again.
And also another good tip would be that if it's nighttime, and there's ice on your sidewalk or porch, driveway, you should probably turn your lights on. Put the porch light on, put the garage light on, so that if people are visiting you, they'll have a better chance of at least visualizing snow and ice on the ground than if you keep it dark. A lot of the cases seem to happen because the property is dark and people don't see snow or ice on the ground.
So a lot of injuries visiting homes are happening because people cannot see.
Yeah.
Okay.
And that's why it's a good idea at night to turn those lights on.
And the lights that you are talking about are the lights of the front porch, if that's the way to enter, by the garage, if that's another way to enter.
Right.
Okay.
So the driveway and the sidewalk and the porch are lit up that way. If there's snowy and icy conditions, at least your visitors will be able to visualize them and avoid falling on them.
So for the homeowner as well as for the visitor, it's really a visual test. For the homeowner, looking to see if there is ice, therefore throwing salt over it, and for the homeowner, looking to see if the salt that they have just placed is now melted and evaporated, therefore giving rise to a need to reapply again. For the visitors, it's also a visual test. Look at all times where you're walking, especially at night, and the homeowners ought to help those visitors by keeping their front porch lights on and their garage lights on.
Correct.
Okay, wonderful advice.
One
Again,
final
yes.
tip would be,
and we're going to take the caller. We apologize. We have somebody who's been waiting.
If you're having a party, probably a good idea to let the guests know that it's cold out. Watch yourself. Watch yourself. Be careful when you come into my house today. Be careful.
However, that's not enough. I think that providing as safe of an area as possible is really imperative on the homeowner.
Sure, I agree.
Mm-hmm. We are for the full hour with attorney Howard Radner, who does have 44 years of experience representing injured people in trip and fall, slip and fall, and the like. And we have 15 minutes remaining. We're going to take one of our callers. Hello.
الو مرحبا.
يا أهلا وسهلا، مع مين عم نحكي؟
الله جهاد.
يا أهلا أستاذ جهاد.
الله يخليك. بس سؤال، هلا أنا تأجرت بيت سنجل بيت لوحده.
نعم.
واحد بس قال لي عمل الليس إنه شو هو شروطه، وواحدة من الشروط إنه I have to buy my own insurance renter.
Renters insurance. أوكي.
أوكي. and إذا يعني ولازم أنا أعمل مع renter إنه cover myself, cover my firm, يعني الفurniture, cover anything.
اوكي، لحظة صغيرة. أول شيء شو anything؟ لأنه الرنترز انشورنس هي فقط لمحتويات البيت.
يعني إنه أنا مسؤول عن الدرايفر كلين، عن السايدوك if something happen.
اوكي، هيدي حكينا عنها من شهر، وبشكرك انه رجعت اتصلت، لانه في كتير فكرة خاطئة، وللأسف الظاهر في بعض اللاندلوردز عم بيحطوا مسؤولية قانونية ما بيقدروا يحطوها على المستأجر، هي عليهم فقط. رح اسأل المحامي هاورد رادر رح يرجع يأكد لنا الموضوع. هيدي مخالفة للقانون. اسمح لي بس لحظة لأسأله. So this is a call we have had before by a lady who, our caller, Mr. Jihad, has a similar question that we answered a month ago. He rented a single unit home, and his landlord made a condition that he buys renter's insurance. And correct me if I'm wrong, that is totally okay. A landlord can require from the tenant renter's insurance. But correct me if I'm wrong, renter's insurance is only for the contents of your home. It's your sofa, it's your TV. It's not for, nor can a landlord shift the responsibility of cleaning the sidewalk, removing the ice on any landlord. A landlord cannot, even by contract, shift that duty onto a tenant. Is that correct?
Yes, the landlord has a statutory duty to maintain the common areas.
استاذ جهاد، القانون بيقول انه كل صاحب بيت عم بيأجر landlord عنده duty statutorily، يعني في قانون بميشيغان، ويا ريت عنا رقم القانون لنذكر لك ايه. The landlord has a statutory duty to keep the common areas مثل السايدوك، مثل قدام الجراج، كلهم هول واجباته هو، مش واجباتك انت، حتى لو مداك بالعقد. القانون بيقول انه المسؤولية عليه and it is by statute، يعني ما فيك تنقل المسؤولية عبر عقد منك لإنسان تاني، حتى لو انت مضيت بقلب العقد انه انت المسؤول عن snow and ice، بعده هو المسؤول عن snow and ice. يعني مبينة كأنه شال المسؤولية منه لإلك، بس الحقيقة أنه القانون إذا صار في شيء القانون بيحمله هو المسؤولية. Attorney Howard Radner, if Mr. Jihad signs a contract, signs a lease in which the landlord makes the lease a condition, that the tenant cleans the snow and ice, that part of the contract is going to be null and void.
The tenant may be obligated to remove snow and ice, but the landlord cannot remove his duty to remove snow and ice.
So what does that mean practically speaking?
Because the landlord has a statutory duty to remove snow and ice.
So you cannot go around it because it's a statutory duty. So you cannot contract away that.
You cannot contract away that. That duty remains on the landlord no matter what he does.
So what if Mr. Jihad has entered into a contract that says he, Mr. Jihad, not the landlord, removes the snow and ice? What happens then?
They would potentially both be responsible to somebody that would fall, the tenant and the landlord. But
what about if the tenant falls, but not the landlord?
the landlord is still responsible for removing snow and ice. He cannot remove that duty.
اوكي سو استاذ جهاد لك ولكل المستمعين اللي هن مستأجرين من اصحاب ملك، القانون بيفرض على صاحب الملك انه هو يكون مسؤول عن السنو والايس والسايد ووكس وكل الكومن ارياز اللي حضرتك وغيرك بيستعملها. اذا انت بالعقد تبعك مضيت انه انت بتتحمل المسؤولية انه انت تنظف، ساعتها ممكن انت بالاضافة لصاحب البيت يكون عليكم خطر اذا حدا قام دعوة ضدكم، مثلا حدا من الامازون او حدا من البوست اوفيس او حدا جاي يزورك. وانما اذا انت وقعت بتقدر تقيم دعوة ضده لصاحب الملك، لأنه هيدي مسؤولية ما بيقدر يشيلها من ظهره ويحطها عليك، حتى لو بالمقابل عم تدفع أجار أقل. Even if he agrees there is some kind of consideration that the landlord will charge him less for the rent if he agrees to take on the removal of the snow and ice. As between the landlord and the tenant, if the tenant injures himself, the landlord is statutorily liable.
Yes.
Okay. However, if a third person is injured, the landlord is, but the tenant may be.
Also.
Okay.
So the injured party could sue both of them.
Okay. فهمت الجواب استاذ جهاد؟
فهمته وشكرا كثير لكم.
يا أهلا وسهلا فيك، وأنا بشكرك على هيدا الاتصال، لأنه في كتير أشخاص بدون شك بالجالية ما بيعرفوا هيدا الشيء. I am sure, Howard, that a lot of people in our community do not know that a landlord's duty to keep the common areas, and we're talking about snow and ice, does the landlord have any other duties?
He has to keep the property in reasonable repair, so that if the gutter or the downspout is broken, he has to fix that.
Okay, so
he can't delegate that duty to the tenant.
He cannot delegate that
That's a
duty.
statutory duty.
Okay, so right now we are talking about snow and ice, but in the summer, in the spring, we don't have that issue, but there are other things that are attendant to the home. What about if it is the steps in the back, going into a garden, or the front porch steps? What if they are wobbly?
He has a duty to keep those steps in reasonable repair under the statute.
Okay. So to those who are listening, a landlord making you sign in your lease that you as the tenant, maybe in exchange for less money for the rent, need to take care of the snow, the ice, anything else. That does not, the landlord may think that he will be absolved of any liability. The truth is he cannot delegate those duties. And so if the tenant gets injured, the tenant will be able to sue the landlord. And if somebody else gets injured, unfortunately, both the tenant and the landlord will be sued.
True.
Okay. Again, we are with attorney Howard Radner, who has 44 years experience. That's a long time, Howard. I'm sure you can write an encyclopedia about slip and fall, trip and fall, and all of these. What about, so landlord-tenant is one of them. Any advice you want to give people about walking and from your car? What did you tell me about when you were visiting your temple, you were praying, and it was 6 or 7 a.m. in the morning, and the parking, the parking structure was very icy. What did you do? And let's use that as an example for shopping owners and store owners. There is the front area, the frontage area where visitors may be coming in and they may slip, or a doctor's office. Tell us about your experience with when you went to pray at your temple.
That happened this winter, and I can tell you that I took some quantity of salt and I spread it myself.
Although you are not part of the temple management.
That's correct. I don't think I had any legal duty to do that.
Right.
But I nearly fell, and I
You almost
I was
fell.
afraid other people would.
Of course.
So I went out, and it was a treacherous lot that morning. I want to tell you that this morning,
Yes.
I happened to drop off some food at a friend's house that they're making a party, and on the grass.
Party on a
next to the
Tuesday?
curb.
On a Tuesday, Howard?
They're making it, I think, tomorrow.
Okay.
So-
on a Wednesday, Howard?
Yeah.
Okay.
So anyway, you can have fun every day of the week, right?
That's true. That's
So-
true.
I dropped off 2 pots of food, and
Did you cook it, Howard, or did your
my,
wife cook
my
it?
wife. I was the delivery boy,
Yes.
so I have a lot of experience being a delivery boy. It was my first job.
To those who are listening, can we share with them that Attorney Howard Radner has 9 children?
So anyway,
And how many grandchildren?
I lost track.
Go ahead. So you have to
Maybe
you have
40.
you have to have settled so many cases and tried so many cases to the tune of millions of dollars to support a family of 11. Correct? Right or right?
That's true.
That's true. Okay.
So anyway, I want to tell you that today it was just treacherous walking from my car onto the grass, onto the public sidewalk. It had not been salted, and I was holding on to my car for dear life to negotiate over the icy grass.
And you were holding things in your hand.
And I was holding pots. Yes, it was really.
So your car was not in the garage.
No,
take
it was in front of the house.
Okay, it was in the front of
where
the
I was
house.
delivering it.
Okay, and very quickly.
That should have been salted. I mean, the homeowner knew I was going to be delivering. The homeowner had business coming out and sprinkling salt over that
You're
ice.
talking about your friend,
My
the
friend.
homeowner.
Yeah.
So you were talking about when you left his home and you were walking.
On the way to his home, I had to be extremely careful in getting the pots out of the passenger side of the car.
Okay, because that was a public sidewalk.
Public sidewalk, the grass between the public sidewalk and the street was icy.
The grass between the public sidewalk and the street. Can you get injured on grass?
You sure can. It was covered with ice, thick ice.
Oh.
Treacherous.
Does that also mean that a homeowner needs to salt his grass?
Sometimes.
That means that you should buy homeowners insurance.
For sure.
Because anything can happen at any time. And if you have homeowners insurance, at least you are covered, and an insurance company will hire a lawyer and pay on your behalf. Let's talk about the public sidewalk that was between the grass of his home and your car that was parked on the street. That belongs to the city.
Yeah, and that was clear.
Okay, and whose duty is it to clean the public sidewalk?
Well, many cities have ordinances that mandate that the homeowner must remove snow and ice from the public sidewalk.
So how is a homeowner to know whether she or he is responsible for cleaning the public, not private sidewalk right in front of their home?
I mean, it's so widespread that I think every homeowner should just assume that he's obligated to do that.
But if someone wants to know, how does one go about? You
could call the city hall
and you give them the address and you ask them whether you are required under the city ordinance of the city in which you live. What about the city you were visiting? Care to share what city?
It was Oak Park.
Oak Park. And is there an ordinance in the city of
There
Oak Park
is.
that every homeowner?
Yes.
So your friend must have cleaned his public sidewalk.
Could be that he did, or it could be that it just melted.
Okay.
But the grass was treacherous.
So the grass.
There is no duty, as far as I know, on the part of a homeowner to salt ice on grass. The ordinance is usually mandated on sidewalks, public sidewalks.
So city ordinances may require a homeowner to maintain, such as clean ice from public sidewalk, but you're not aware of any city ordinance requiring, as far as city ordinance, but requiring ice on grass. However, the homeowner may want to do that or tell visitors, do not use the grass, or put a sign. You know, almost all of us do think that if you walk on grass, you're kind of safer. Based on what you're telling me, not if it's a sheet of ice. What about if you're looking at the grass and you see that it's covered with snow? Do you think that the snow may provide a cushion even if under the snow there is ice?
I do.
So
I
it's
think it's safer. I think it is safer.
Safer to walk on grass if it's covered with snow, even if there is a sheet of ice beneath it?
I think it's still safer than walking on ice-covered sidewalk.
Okay, because the snow may provide a little bit of a cushion.
Bit of traction.
Okay, may provide a traction. I think that the time is almost up. This was an extremely helpful session again, and we hope to have you again next month. On Friday, I will be wrapping up. I hope to wrap. Well, not this Friday. Actually, next Friday, I will wrap up this discussion today, because you have given extremely valuable information to tenants, about whether their landlords can put on them the duty to, keep the ice and the snow, the visual tests that we talked about, the city ordinances for homeowners who may require them to maintain the public sidewalk clean. These are very valuable information, and I thank you very, very much for it.
Pleasure. Thank you for having me.
In fact, Rami, if we can choose to run this program on Sunday, because Attorney Sam Saif will be here on Friday to cover for me as well, because I have a seminar that I need to attend, a legal technology seminar. So with your permission, if we can have this show repeated on Sunday as an exception, hopefully people will get to catch it again, and it will be on YouTube and it will be on our website. Rami, thank you very much. Attorney Howard Radner, thank you very much for very valuable information. We pray it will prevent further injuries, and we hope to see you again next month.
Thank you for your kind remarks.
Thank you.
Enjoyed it very much.
Thank you.
نشكر لكم مستمعينا حسن المتابعة. إذن كما ذكرت جومانا، هذه الحلقة ستعاد يوم الأحد إن شاء الله في تمام 7 مساء على راديو سينا 102.3 FM، وأيضا ستكون موجودة على الموقع الإلكتروني yourrights.com/radio وعلى اليوتيوب. تحياتنا لكم وإلى اللقاء.